beg to mention item number 10.
10, yes.
Beg for Lordship indulgence officer. Can the matter be taken up after vacation?
Why?
Lordship, on behalf of Mr. A.M. Bora, there is some difficulty, Lordship. Kindly, Lordship, after vacation. I've informed you, I could not inform yesterday, but today I did it. In the morning.
I is there, my objection is on record.
On record, they have
I
filed their
know.
objection.
Okay, right. On the prayer for adjournment made on behalf of Mr. A. M. Bora. This is the matter after the vacation. Full stop. As the LCR has arrived. Registry to prepare the paper book.
Lordship.
Then in the IA, you write. And the state has filed the written objection. This is the matter after vacation.
Highly obliged, Lordship. Obliged.
Yeah, my lord, I in my lord, so much control number 223, maybe listed tomorrow, my lord. Yesterday,
So much of contempt number 20.
my lord, in which, my lord, in matter bill number 4, lordship plus order for 1 month imprisonment. In the meantime, our liberty was granted, he paid installment, he has paid already, my lord, so matter may be taken tomorrow, my
Okay. So much of writ petition.
lord. No contempt was done, my lord, in matter.
Okay.
May I please,
So he has paid the amount
Yes, ma'am.
after going to jail. So it needs you to be sent to jail to pay the amount. And
No, and also, my lord, compromise has been made that they have to waive the other amount. And they also filed.
May I please, your Lordship. Lordship, I beg to mention for listing of one appeal, Lordship, for admission, Lordship. He was convicted under section 6 for 21 years, Lordship. Kindly of the tomorrow, Lordship.
when
Tomorrow, Lordship.
appeal
Lordship,
for what?
for admission, Lordship. Last time, Lordship. Obliged, Lordship.
Yes, what is your name?
Lordship, Ayu Chaudhary, Lordship.
Yes, heard Mr. Ayu Chowdhury, learned counsel for the appellant. This is an appeal against the judgment dated 5/9/2023 passed by the court of the special judge bracket POCSO, Pokraja in case number special 06/2022, by which the appellant has been convicted under section 457 IPC, allied with section 4 of the POCSO Act. Ms. B. Buyan accept notice on behalf of the state. Actually, before that, you say admit the appeal, call for the LCR. Huh? Admit the appeal. Ms. B. Buyan accept additional PP accept notice for the state. Who is the respondent number 2 is here?
Lordship, I think Sartina will be, Lordship.
Huh?
We have implicated party, Lordship, as response number 2.
Who is she? What is her relationship with the victim?
Lordship, she is mother, Lordship.
Is the mother?
Lordship.
Okay, right. The appellant shall serve a scanned copy of the appeal petition to the registry of this court within 3 days. First of the registry shall thereafter furnish the same to Ms. B. Buyan, learned APP, who shall transmit the same to the OC of the
Usaigaon PS.
Gosaigaon Police Station,
Lordship.
in as much as the matter pertains to Gosaigaon PS case number 422/2021. Dated 27/3/2020. The OC shall submit a report thereafter, shall submit a report after serving the same to the respondent number 2.
Yes.
Let the matter for 4 weeks. Then in the-
She
I-
will accept notice on my behalf. P. Bora's name to report.
just say instead of this accept notice, you just say Miss B. Buyan, additional PP appears for the state. That's it. And then in the IA, you write Ms. Buyan, learned APP is granted
4 weeks.
4 weeks time to file written application
Obliged.
to the application under section 389. Yeah.
Obliged.
I mean,
My. All this. It's on the side. Yes, next, item 2.
There's some overwriting was there in the birth certificate. Now that original is on, it has come. Lordship has requisitioned. Now original also there is an overwriting.
So is it, now what to do?
Lordship will just see the original birth certificate. It was issued in 2008. It's marked, it's I think the last page of that file. The yellow flag or the red flag. Last page, perhaps, last page. Last page, isn't it? Oh.
Transmission of the original birth certificate of victim. Where is this?
It's there,
Ah,
it's
this, yes.
on the next page.
This 2201.
Even I feel it's one because it's written in English. Date of issue is 2008, that is in Assamese. And it seems 2001, but there is again a cut.
Again, overwriting.
Something has been cut. Lordship will take it up for hearing this matter. The paper book is ready.
Very fixed for hearing.
Okay, right. Mr. G. Uddin,
Jainuddin.
Jainuddin, learned counsel for the appellant. And Miss L. Jahan, learned ABP, submit that they have received copies of the paper book. Put up further. The learned trial court has sent the original birth certificate of the victim.
Hmm.
Which is flagged in this a court record. Accordingly, leave this matter for hearing in individual courts. Respondent here,
The name is appeared. Rajput here.
right? Miss
S. Nalini.
S. Nazneen, learned counsel for the appellant, and Miss L. Jahan, learned APP, submit that they have received, B. Buyan. Learned APP, submit that they have received copies of the paper book. Pusta. However, no one appears for the respondent number 2, even though the names of the counsels are reflected in the call list. Pusta. As in view of the submissions made by the counsel for the appellant and the learned APP, leaves the matter for hearing in usual course.
Deeply obliged. Arup obliged.
So we have received a copy of the paper mobile.
So we'll fix it for hearing.
Yes,
Okay, Miss B.B. Narzari, learned counsel for the appellant, and Miss B. Buyan, learned APP, submit that they have received copies of the paper book. Accordingly, leave this matter for hearing in usual course.
This is an appeal against acquittal, Your Lordship. He was acquitted under the PC, Prevention of Corruption Act. But as far as notice is concerned, it is not served. But this is a leave application, Lordship can, it is actually between the court and the
No.
litigant. Any leave,
No, that is a different issue, but there's also condonation.
a condonation that is condoned. Perhaps
Condoned?
no condonation, there was no condonation in this.
No,
appeal.
but then you see one thing out
That-
here, madam, one thing is that the order of this court was that notice should be issued
Huh.
on 17/5. Then on 19/6, Miss S. Jahan,
Hmm.
then the APP submits that she will take steps for issuance of notice to the respondent
Hmm.
within 2 days.
Hmm.
Then on July,
Hmm.
it says that notice received back with remark insufficient address.
Address, yes. Then we corrected, we had sent
She
again.
accordingly prays for some time to obtain the correct and
Ah.
full address of the respondent.
Then we had sent him again. The father's name was not there. I collected and I've sent it.
Then,
And then again answered, I think, no.
so no answer,
No
notice
answer.
or nor AD is received.
Huh.
Now, whether that is the correct address where you sent, we don't know. What is the correct address?
No, the address was okay, but then father's name was not there, so we have taken it afresh. And because Mr. Anshuman Bora had appeared, I'd taken him, I took the father's name from him and then I've sent it. Address is otherwise
Mr.
same.
Anshuman Bora appeared for whom?
He appeared in the lower court for Mr. Pankaj Gogoi, Sri Pankaj Gogoi. He was there in the court on that particular day when this insufficient
But then
report came.
the correct address is not part of the court record.
But then I had corrected, I had given a house number also. And father's name also I had given that time.
Give me the other files. Where do we know where is the correct address you have given? Nothing is reflected in
Nothing
the
is-
office note.
But when I had sent it,
But
there's a,
shouldn't you have also made a correction to this petition? A correct address, because now on the records is the wrong address.
hmm.
Okay. Now, you see, now which address are we supposed to accept?
Dokhin Sarania PS Fulton Bazaar, but then I think I had also given his house number.
Uma Kanta.
Umakanta is the father's name. Perhaps I repeat. Oh, okay. That one I had written it earlier. Then I'll correct it and I'll file it afresh then, but then now leave application.
So,
A corrected application I'll have to file that.
because there are two fathers, different.
Hmm.
In the leave, that's okay.
Not sure.
In, I mean, in the appeal, it's okay. In the leave application,
Ah,
you've got Sri
Two.
Pankaj Kumar Gogoi, son of late Umakanta Gogoi. But in the next page, page 3,
there,
son of Sagar Chandra.
I don't know what mistake was committed. And here it has to be a copy paste thing. Because here entire the
And out
address
here
is
it's
different.
it's
Karbi
after,
Anglong and all.
Karbi Anglong.
So this is totally a copy paste mistake. I'll
Oh.
file it afresh.
You file afresh. You file which afresh?
Amended leave petition only.
Then you have to file an application.
Yes,
We just cannot do that.
I'll have to file an application.
Or you withdraw this and file afresh or what?
And no, I'll withdraw only the leave, otherwise the delay will
Delay,
come.
okay. Okay, that's how we withdraw only the delay. Let's leave.
Only the leave and
Okay, right, Miss El Jahan, additional PP submits that she would like to withdraw the criminal leave application. File under section 378, right? No, file under
378(3).
378(3) CRPC. In view of the fact that she has given two different addresses of the respondent. Full stop. She prays that she may be allowed to file a fresh leave application after withdrawing the present.
I
The prayer-
tender my.
Huh?
I tender my biggest apology. This is. really
The
mistake.
prayer of the prayer of the learned APP as Jahan is allowed. The application is dismissed as withdrawn, with liberty and pay.
Not sure. I'm not like.
So we made we made the paper book
Eight.
in the appeal. Correct,
Eight, I don't have the, oh yes, paper book is not ready.
paper book has to be made.
Yes, lordship. I think there's an I also.
I is there, you have not filed your
No,
WO.
no, it has come up for the first time, I did. It has
Okay.
come up for the first time.
In the criminal appeal, you write as LCR has arrived, registry to prepare the paper book. List after 4 weeks, huh?
Lordship.
Then in the IA, you write, Miss S. Jahan, learned APP is granted 4 weeks time to file written objection to the application under section 389.
Lordship.
List after 4 weeks. I live.
No, paper
Yes,
book is.
Your Lordship, my lord, this case matter LCR has been received already, but one respondent number 2 notice is not served. I am appearing on behalf of S. Legal Council, my lord.
Poxo, yeah?
So paper book has to be
Poxo is
made.
not, it's not a Poxo matter, so no.
It's not a POXO matter.
No, not a Poxo matter. So let the paper book be made.
Yes,
and-
right, as LCR has arrived, registry to prepare the paper book, list the matter after 4 weeks.
Respondent number 2 নালাগে, নালাগে, নালাগে।
No, please, the lordship. The lordship, as per order dated 7/8/23, we have taken step upon respondent number 2.
And I think it has been received also. That is what has been said.
দেবেন?
AD card has been received by the
Achha.
concerned section. Show me the supplementary file. Supplementary file.
মেকানিকে এবো হেৰি।
Right,
ও মত
Mr.
Yes, Paul, your lordship.
S. Paul appears for the appellant,
দেবেন আছে?
while Ms. L. Jahan, learned ABP appears for the state. No one appears for the respondent number 2, even though
Objection there is not. No, no,
but there is no signature of the addressee. No signature of the addressee. So that is a signature. No one appears for the respondent number 2, even though the respondent number 2 has given a signature in the AD card that has been returned back. Full stop. Accordingly, notice is deemed to be served upon the respondent number 2. As LCR has arrived, a registry to prepare the paper book.
I'll file my objection.
Then you write, leaves the matter after 4 weeks. Then in the IA, you write, Ms. S. Jahan, additional PP is granted 4 weeks time to file. Written objection, leaves the matter after 4 weeks.
Oblige, your lordship.
What's the question? Here there is a delay. Delay of. And we were supposed to file objection.
Lordship, there was a delay notice was issued, Lordship.
I think we had taken some time on the last occasion.
Or any objection?
Lordship,
Of course,
let's let it
we'll
be
allow
on
it.
merit.
Heard Mr. B. Chakravarti Learned Council for the Chakravarti will be what? Will be Bengali or V will be what?
In both parents.
Chakrabarti. Chakrabarti,
Assembly
there are
also.
Bengalis. How come
No, V is usually SME, no, V is
He is generally in SMS, Lordship.
V is generally in SME, V
V.
and P.
He generally in Bengali.
No, I don't think so.
No, interchangeable, they use whatever, like Mukhopadhyay and Mukherjee. Like that, I think.
Gangapathy and
Sometimes it is P-A-R, Bharti, and some B-O-R.
BOR,
uh,
Bharti.
So, and then there
Whatever
is
they
V
feel
also. Now everything is getting mixed up.
Numerology, maybe based on numerology, Lordship.
Okay.
Oh, he is asking me that.
Heard Mr. B. Chakravarti, Learned Counsel for the applicant, who submits, there's a delay of 2307 days in filing the appeal against the judgment and order dated 29/2014, passed by the
Session judge,
Sessions Judge, Tinsukia, in Sessions Case number 172/T/2012, by which the applicant has been convicted under section 302/323 IPC and sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, IDRI for 6 months under section 302 IPC. Full stop. He has also been sentenced to undergo. He also been sentenced to pay a fine of rupees 500.
5,000. Lordship.
Five? Your application says 500.
Mhm. 5,000.
Then your
no,
application is wrong.
5,000 in default of life, pay in default of fine in respect of life.
That is 302. And
302.
what about 323?
500,
500.
sentence to pay a fine
Comma,
of 500,
in default, RI for 1 month
1 month.
under section 323 IPC. Full stop. Next para. The applicant's counsel submits that the applicant, being a poor tea garden laborer coming from the lowest strata of the society, has little means of subsistence. Full stop. As such, besides being unaware of the legal process, he could not approach lawyers to pursue challenging the verdict due to poverty. Full stop. Further, he being the sole bread earner of his ailing wife and minor children, the applicant could only make contact with one advocate in October 2017, who however became ill with a terminal disease. It was only full stop. It was only in October 2021 that the brother of the applicant came to know of the problem being faced by the applicant. Full stop. Accordingly, the applicant came to what have I said last? Not accordingly. Full stop. You said thereafter, the applicant came to know that he could file an appeal through the jail authority, and accordingly, on 31/8/2022, he made a request. He made an appeal via the 1-page letter and asked the jail authority to forward the same to this court. Thereafter, the jail authority, by letter dated 1/9/22, forwarded his 1-page letter / appeal to this court. Subsequent to the above, the applicant could contact the present counsel, who took up his case in March 2023 and prepared the appeal. Full stop. The applicant thus inadvertently filed the appeal after a delay of 2307 days. Full stop. He prays that the same should be condoned. Full stop. Ms. S. Jahan, done an additional PP, submits that she does not have any objection to the delay being condoned. Full stop. Next paragraph. On considering the reasons for the delay given by the applicant and keeping in view the submission made by the learned APP, comma, we find that sufficient cause for the delay has been made out. Full stop. Accordingly, the delay of 2307 days is condoned. Registry to prepare the registry to register the appeal and list the same accordingly. I is accordingly disposed of.
Appeal can be registered? Yes, yes, Lordship has already done.
I said that. I said that registry to register the appeal and list accordingly.
Objection is no.
So this is third future asset. My lord, here 13.
13. 13, ठीक है?
My lord, the application number bail on the 389 is filed, my lord. My lord, this is murder case 302. The man who killed was his
Own brother.
was killed was his own brother.
Informant is the father.
And the informant is father, my lord. Father also died, my lord, he's in jail. And one brother is dead. Now he is 72. Now he was 70 septuagenarian. So my lord, can I pray for a preparation paper book, my lord? Then only bail may be considered, my lord. My lord, because otherwise your lordship can consider granting of bail also. 73 years old man, in heat of moment, one blow only, my lord. It should come under 304 part 2.
When did this incident occur?
It was incident occurred, my lord, in 2001.
2001, when? Date.
Date, my
Give us
lord.
the file.
Date of offense is 14/8/2001.
14/8/2001. How long has he been in jail?
My lord, firstly he was the mental period 3 months, then he was granted bail, my lord. Then from the date of conviction, my lord, from 13/6/2023.
13/6/23.
Yes. Only on the ground of age, my lord, and only one blow was given by the other. Just the heat of the moment in the shock. Something happened, I don't know. Both of them went together.
Let us see the judgment.
Judgment, my lord, page 5 onwards. 5 of the appeal.
Let us see the medical report, the medical doctor's evidence.
Just a minute, my lord. Yes.
Number 25.
My lord, I have also got the proportional report also.
Second rib of the right side broken,
Yes.
right lung torn and collapsed,
Yes.
penetrating sharp, perhaps one wound only.
Only one blow, my lord. That's why postmortem report. Both the brothers went together to the tailors of my lord. There, what happened, my lord? He picked up the one dagger was lying there, picked up and picked up. There was some quarrel, and in the investigation is very lackadaisical manner because nothing could be found out. What is the reason for the quarrel? And what is the reason for immediately hitting the person?
So his other persons in the shop, they saw, no?
Yes, the teller was there. He has, one of them is eyewitness. You know what I mean? It will please not be wrong.
Wait, he absconded.
Pardon?
He absconded. The long absconding of the accused
Yes.
A1 from the date of incident till 2017.
Yes. He ran away.
And then there is no reason as to why he has stabbed him out.
No,
No
no
reason,
reason.
that-
In the
Huh?
investigation matter, nothing was.
But
Okay,
then,
so-
but then you ran away and then you came into the room and you stabbed him without any reason. It appears there's premeditation.
Yes.
My lord, premeditation, my lord. Because both the brothers went to the shop in the morning.
No. 2, 3, 4 were the eyewitnesses. They had
Yes, yes. They were in
seen
the
him
shop.
coming inside and giving the blow.
There is contradiction also, my lord. Based on the judgment, my lord, there is some contradiction was found, my lord, between the EW 1 and 2. There was what was noted by the trial court also.
The records are here.
Yes.
Just show me the P1 statement.
Total denial, it seems, from the judgment. Total denial from the judgment as it is written.
Okay.
My lord, in PW 11 is the IO, my lord.
Yes,
He also could not extract anything, my lord.
In view of the oral.
there are eyewitnesses.
Ocular evidence.
No,
which
no,
affects
I
the
would, no, no,
best-
that is, my lord, not deniable, because killing is there. One
He-
photo was
he's-
given.
He's hardly in jail also. He's hardly, let him be there for some time.
In the meantime, paper book may be allowed to do.
Paper book will be made. In the meantime, we are dismissing your petition. Right, in the criminal appeal. In view, Mr. R.P. Sharma, learned senior counsel, appearing for the appellant, and Ms. S. Jahan, additional PP. As LCR has arrived, Liz registered to prepare the paper book. To establish the matter after 4 weeks. Then in the IA, you're right. Heard Mr. R.P. Sharma, learned senior counsel for the applicant. Also heard Mrs. Jahan and learned APP, full stop. This is an application under section 389 CRPC for suspending the sentence imposed upon the applicant pursuant to the judgment and order judgment dated 13/6/2023 passed by the Sessions Judge Lakhimpur in Sessions case number 160 bracket NL 2017, by which the applicant has been convicted under section 302 IPC and sentenced by its sentence order dated 15/6/2023. As to undergo
Page 44. Page 44 of the appeal, my lord. Undergo life imprisonment and to pay 10, fine of rupees 10,000.
to undergo rigorous imprisonment for life with a fine of rupees 10,000, in default, simple imprisonment for 1 year. Full stop. The learned senior counsel for the applicant submits that the applicant is a 72-year-old person who has been accused of, who has been convicted for killing his brother. Full stop. He submits that the informant in the case was the father of the applicant, who has also subsequently expired. Full stop. He submits that the evidence of the witnesses go to show that there was only one blow made by the applicant with a knife on the deceased. And as such, it cannot be said that there was in any intention on the part of the applicant to have killed his brother. Full stop. He submits that due to the old age of the applicant should be released on bail. Full stop. Ms. El Jahan, the learned APP, on the other hand, submits that PW 2, 3 and 4, is it 2, 3 and 4, being eyewitnesses to the applicant stabbing his brother, comma, there is no ground to suspend the sentence or release the applicant on bail.
Moreover, his abscondence.
Full stop. Further, the applicant had also absconded for 16 years. For 13 years, for 13 years, 16, for 16 years,
1 to 7.
for 16 years. And as such, bail should not be allowed. Full stop. We have heard the learned counsels for the parties. Full stop. The incident of the applicant having stabbed his brother, which resulted in his death, occurred on 14/8/2001. Thereafter, the applicant has been absconding and had been arrested only in the year 2017. Full stop. Further, the evidence indicates that, and further, the evidence recorded by the learned trial court shows that there were eyewitnesses to the act of the applicant applicant killing his brother with a knife. Full stop. On considering all the above factors, comma. No, have I talked about that absconding? No. Now, further, the records show that the applicant has been absconding for more than 16 years. Full stop. On considering all the above factors, comma, we are of the view that no case for suspension of the sentence or releasing the applicant on bail has been made out. Accordingly, the application is rejected. I is accordingly disposed of.
Obliged. Obliged.
Yeah, my lord, we took steps upon the respondent number 2, my lord, 3 times, my lord. The
No,
POCSO
Lordship,
case, my
it was yesterday.
lord.
Okay.
There's a IA, my lord.
I probably we have not filed our objection.
Yeah, fine, yeah, fine.
Look, I have prepared a written argument and a compilation of the judgment that we are relying upon. Below. I'd like to.
Yes,
But if your lordship can take that compilation, Milord.
Yeah.
In that written argument, if your lordship can see that I have just that page 4, Milord. I have just framed from my side, Milord, for convenience of your lordship, Milord. 3 issues that may be propped up for adjudication before this honorable court. At page 4, Milord.
Yeah.
Paragraph E.
Yeah.
Well, prior to coming to the issues, if your lordship can, I may be given up just 2 minutes time to just refreshing of the whole things. That the appellant before your lordship, he was initially appointed as a LD of this court, my lower divisional assistant in the year 2004. Then my lord, on 16/11/2011, he was promoted.
Look, no one is really bothered about that LD, I think, from
Just-
from SJ it starts.
Yes, yes. My lord, he was as from senior judicial assistant, protocol officer,
Then protocol officer.
then protocol officer to secretary. Now the question is, my lord, from senior judicial officer to protocol officer, there is no dispute. Nobody has challenged this appointment.
But then the protocol officer, what does the appointment order say?
Yes, I'm coming to this. In appointment orders, my lord, there are two sentences at the below. That he will maintain his seniority in the senior judicial officer. That is the whole problem. Now the question before your lordship. That is
And
why-
it says temporarily appointed, or what does it say?
Yes, it says, no, it doesn't say temporary. The word temporary is there. The word temporary is there, my lord. Lordship has taken note of whole things.
No, I don't know, let's see.
The word temporary is there in the appointment order, 144 page number,
144 of what? This?
my appeal memo.
And the-
Now, this is compilation for the judgments.
Which appeal? Which appeal?
5.
One,
144. The word temporary is there. Got a good service to so and so. Honorable the Chief Justice has been pleased to appoint Shri Nihut Sharma, Senior Judicial Assistant, temporarily and until further orders, as protocol officer in the principalship, grade pay so and so. Second paragraph, Shri Nihut Sharma will maintain his seniority in his original cadre, that is Senior Judicial Assistant, and his further promotion will be considered on that basis. Whether this sentence and the word temporary incorporated in the appointment orders will make the appointment temporary.
correct,
That is one issue.
correct.
If your lordships decides this issue in favor of the appellant, the remaining issues will come automatically in favor of the appellant. Because if.
So the first hurdle in the
Yes,
entire
whether
issue,
this is a temporary appointment or substantive.
correct,
This is the first hurdle
that is,
and this is the last hurdle.
no, we'll have to.
This will
We-
overcome,
We will go to the next hurdle when we cross this.
yes,
First you cross this hurdle.
yes, that is what I'm saying. But if we can cross this hurdle, the remaining thing will become easier.
Might not. Depends.
Yes, my lord. That's what you comes from your lordship's mouth, my lord. Now, my lord, the page 4, my lord.
So the first question is whether
Page 4, paragraph E, my lord.
this is appointment of appellant as PO in terms of notification dated 25/11/16 is a regular appointment, is regular promotion,
Substantive appointment.
is substantive.
Yes. Now, I just proposed the issue on this point, whether the Lanet Singelius was correct in holding that this is a temporary appointment. Now, the Singelius has held, my lord, that this is a temporary appointment. So we challenge before this law. Another issue, my lord, that may be important, my lord. Page 4, my lord, paragraph Roman 2.
Yes.
Whether the Honorable Chief Justice or the Registrar of the Honorable High Court had violated any prescribed rules while appointing Shri Nihut Sharma as the Secretary to the Honorable Chief Justice, and thus Article 14 of the Constitution was violated vis-a-vis the requisitions. Because the next challenge is, my lord, while he was officiating basis appointed as a secretary, that was challenged in the first petition. The ground of challenge was that Article 14 was violated. Whether it was there or not. The third one, my lord, whether learned single judge in judicial review can go into that extent to say that the decision was made inadequately. Reasons were inadequate. Whether in judicial review, single judge can go into that. This three issue as a whole, my lord, if lordship definitely can change or alter it. Just as a proposed from my side. Now, my lord, if your lordship can come to the page 160 of the writ appeal, that is the impugned judgment, my lord.
Writ appeal number 5.
5. Lordship will take 5 only. I'll refer to 5 only. Page 160 is the impugned judgment. The fourth line, my lord, I'll read only the required portion only, we are having some voice issue. The fourth line, this sentence starting with the word, the challenge is mainly based upon the lack of eligibility and qualification of the said respondent number 5 in both the aforesaid processes. This is the challenges in both the writ petitions. There were 2 writ petitions, my lord. When I was appointed as a officiating basis secretary to the Chief Justice, and when the second one, when I was regularized in that service. These 2 challenges. Now, next page, my lord. Land signatures are held it from the
Yes,
next page, page 161, the fourth,
yes,
fourth line, my lord. This line started with the respondent number 5 was appointed as a LDA so and so, and thereafter was promoted to this career of senior judicial assistant, which is holding a substantive capacity. The said post of SJ in the feeder cadre to the put of administrative officer judicial, which the petitioners were holding. On 25/11/2016, the respondent number 5 was appointed as protocol officer temporarily. This is his finding, recording, not finding, it's recorded as it was temporarily. Now, my lord, I'd like to address the issue one by one. Why it is not a temporary appointment? Why it is a substantive appointment? My lord, may I take your lordship to the paper book? And the word used in the appointment letters and the condition given in the appointment letters makes no sense. That I'm showing from the judgment of the Honorable Supreme Court and High Court, our High Court in Division Bench of Assembly.
so long as the selection process is done as per rules, is it?
Pardon me.
So long as the selection
Yes.
is done as per rules.
Yes, if the selection is as per rules, if the selection is advertised, if the appointment is advertised, if there is selection, if there is a separate pay scale, if he is delivering substantive duties for a quite considerable long time, then this is not temporary. And the next judgment, my lord, the incorporation of the word temporary or incorporation of the terms of appointment which dehors the rules makes no sense. Supreme Court says, I'm showing to this.
Yeah.
My lord will come to there, my lord will see that paper book, the page number is given in a bold letter at the top.
Yes,
Paragraph 18, my lord,
page,
page number 5. Page is 9 of that paper book. Paragraph 18 and 19 is important. I'm reading, my lord.
yes,
The question whether the terms embodied in the order of appointment should govern the service conditions of employees in government service, or the rules governing them is not an open question now. That means it is decided. It is now well settled that a government servant whose appointment, though originates in a contract, acquires a status and thereafter is governed by his service rules and not by the terms of contract. The powers of the government under Article 309 to make rules to regulate the service condition to its employees are very wide and unfettered. These powers can be exercised unilaterally without the consent of the employees concerned. It will therefore be idle to contend that in the case of employees under the government, the terms of the contract of appointment should prevail over the rules governing their service conditions. Meaning thereby, my lord, that the service conditions embodied in the terms of appointment in the appointment letter is of no use if it is otherwise in the rules. Next, my lord, I'm taking your lordship to the in the later part of the page, my lord. The origin of government service often times is contractual. There is always an offer and acceptance, thus bringing it to being a completed contract between the government and its employees. Once appointed, a government servant acquires a status and thereafter his position is not one governed by the contract of appointment. Public law governing service conditions steps in to regulate the relationship between the employer and employee. His emoluments and other service conditions are thereafter regulated by the appropriate statutory authority empowered to do so. Such regulation is permissible in law unilaterally without reciprocal consent. This court made this clear in two judgments rendered by two constitution benches of this court in Rosenlal Tandon versus Union of India and State of J&K versus Trilokinath Khosa. Thus, it is clear and not open to doubt that the terms and conditions of service of an employee under the government who enters service on a contract will once he is appointed be governed by the rules governing his service condition.
This is on a slightly different footing, Mr. Counsel. This is when a contract employee comes into the
No,
government.
why the genesis of this findings is not. I'm coming to the next paragraph, the next judgment, genesis of this findings, my humble understanding, once, but there is no rules prescribed in the High Court services rules. What will be the service condition of a protocol officer? If there is no rules prescribed,
You see, each decision has to be decided. It decides a particular case on the basis of the facts and circumstances
Of that
pertaining to that particular case. Out here, this is not the issue where he was a contract employment and then he was taken
No,
into
I-
regular government service. That
my
is,
respectful submission, though this is
so
not.
you are trying to fit in the words there. It's on a different context.
Context may be the different, but the thing is that the question of permanency of a particular appointment is being questioned.
No, but this is, you see, you'll have to, you cannot say that the words used here can ipso facto be applicable to the facts in this case. You'll have to give
That cannot
another.
be in any case, not in this case.
Yes,
That
no,
cannot be in any
no,
case.
no.
We have to follow the genesis of that particular findings of the.
No, this is in a different context altogether. The context is different.
My respectful submission, my lord. When the permanency, why I am citing this judgment, my lord. The terms of appointment that his seniority will be maintained in a lower cadre.
No, the issue is this. Now, if he's called temporary, according to you, temporary means regular. And regular means temporary.
No.
Is that?
Not
What-
at all,
what
not
are they?
always. That is what our High Court also says. I'm
Ah.
going to show to your
Ah.
lordship. Temporary always does not mean temporary. Temporary is just a usual course of officialis. That is language used
Correct,
in the
correct.
official word.
So
Official word.
temporary will, temporary in all cases would not mean temporary.
Temporary.
Yeah.
And I'm showing to your
Show
lordship,
that, but
other
not,
judgments,
I don't think this one will help you that.
why I am referring to this judgment, but I leave it to your lordship whether this will help me or not. That your lordship will decide. Why I am citing to this judgments, my lord. when there is no service condition attached to the rules, merely because it has been mentioned in the appointment letter, makes no sense. To show that only, to show that genesis of a service jurisprudence, I'm referring to this. I'm not saying that it is fit to my facts and circumstances. No. Service condition, if derogates the anything, say derogates the rules, will not make any sense. Next, your lordship will see with that paragraph, my lord, next page, my lord, paragraph 5, the lordship will see at page 11F in that book, my lord, in our judgment, our High Court judgment, my lord.
Where?
That book itself,
Uh-huh.
paragraph page 11F,
11.
11F.
F.
F for
Why
foreign.
do you have F?
No, my lord, there were some pagination mistakes, so that is why I have to make it ABCD. Paragraph 5.
Para 5, yes.
Referring to this earlier judgment that I have just read out, this honorable court has held. In a decision reported in 1986, 1 SCC 6 so and so, the apex court has held that where the statutory rules are enforced, the terms of the service would be governed by such statutory rules and not by any condition service which may be incorporated in the letter of appointment. Therefore, merely saying in the order that the appointment was temporary will not make it temporary, since no such appointment is envisaged under the rules. The rules envisage substantive appointment against the post in the cadre, and on successful completion of probationary period of statutory period, the incumbent has to become a confirmed employee on the post indicated. My respectful submission, my lord. In our case, we are one step ahead, one step in advance, because this is not even a probationary post,
There's not a promotion post?
probationary.
Probation.
It was not even a probationary post. It was substantively appointed. Now, my lord, I will take your lordship. Next, my lord, in that booklet itself. That Baleshwar Das case judgment that day I read, my lord. If lordship wants to hear me once again,
Yes, yes. We forget everything.
then my lord come to page 19, paragraph 9 of that paper book.
Yes.
Paragraph 9, my lord. So the order of appointment to the service is decisive of seniority, and the service horoscope of each assistant engineer has to be cast with reference to his appointment order. The next question then is, when is an engineer appointed to the service? When under the rules he becomes a member of the service. For until he gains entry into the service, he cannot claim to be appointed to it. To hover around, which prospects of entry is not the same as actual entry. Therefore, we have to examine when an engineer becomes a member of the service under the rules. Clause B of the Rule 3 defines member of the service to mean a government servant appointed in a substantive capacity under the provision of these rules to a post in the cadre of the service. When then is the cadre of the service? What do we mean by appointment in a substantive capacity to a post in the cadre? Can there be a temporary post included in the cadre? Here, Rule 4 becomes relevant. Rule 4 prescribes the sanction strength of the cadre. It provides that the government may, subject to the provisions of Rule 40 in the CCA rules 1930, increase the cadre by creating permanent or temporary posts from time to time as may be found necessary. So, a cadre post can be a permanent or temporary, and if an engineer were appointed substantively to a temporary or permanent post, he becomes the member of the service. The touchstone then is the substantive capacity of the appointment. Here we get into the service jargon, which slippery semantics and flavored officialis. whatever may be the language used in the appointment letters, in my humble understanding, that cannot alter the nature of appointment. Now, my lord, in this judgment itself, if I can take the lordship to paragraph 29, page 28. Thank you, lordship, got it. Page 28, paragraph 29.
Yes,
Substantive capacity is a flexible expression which cannot be frozen by current officialis, nor by the conditions that obtained in the remote past when the rule was framed. On the contrary, its meaning must be consistent with Article 16 and must avoid the pitfalls of arbitrariness and irrational injustice. So viewed, we hold that appointment need not necessarily be to a permanent post. It is sufficient even if it is to a temporary post of long duration. In a department which had permanent post and temporary post of a quasi-permanent nature, there is not much to distinguish the quality of service as between the two. But Patwardhan case and Chauhan case have primarily or in passing clarified the equal value of officiating service. In Patwardhan case, justice understood, as he then was observed in the course of discussion, since next page is not necessary, then your lordship will come to page 30, paragraph 31 of that page, page 29. What in the context is a substantive capacity vis-a-vis an appointment to a post? In our view, the emphasis imparted by the adjective substantive is that a thing is substantive if it is an essential part or constituent or relating to what is essential. We may describe a capacity as substantive if it has independent exercise or is of considerable amount or quantity. What is independent in a substantial measure may reasonably be described as substantive. Therefore, when a post is vacant, however designated in officialis, the capacity in which the person holds the post has to be ascertained by the state. Substantive capacity refers to the capacity in which a person holds the post and not necessarily to the nature or character of the post. The approximate to the official distinction used in this connection, we may well say that a person is said to hold a post in a substantive capacity when he holds it for an indefinite period, especially for long duration, in contradistinction to a person who holds it for a definite or a temporary period or holds it on a probation subject to confirmation.
so is this in your favor?
Yes, my lord. Then, my lord, will page 30, paragraph 30,
No,
next
no,
paragraph.
the capacity in which the person holds the post has to be ascertained by the state. Substantive capacity refers to the capacity in which a person holds the post, and not necessarily to the nature of the character of the post.
Yes,
So the nature of character is not important.
not important. I
Refers
am
to the
delivering a
capacity.
substantive duties. That is enough. It will, in some, one more judgments are there, which will,
I don't know if you are.
this
reading
doubt
the-
will, this clarified in a later judgment I am showing to you. Lord. Next paragraph. Once we understand substantive capacity in the above sense, we may be able to rationalize the situation. If the appointment is to a post and the capacity in which the appointment is made is of indefinite duration, if the Public Service Commission has been consulted and has approved, if tests prescribed have been taken and passed, if probation has been approved, one may well say that the post was held by the incumbent in a substantive capacity. All the conditions we fulfilled. There was advertisement, there was selection, there was approval, there was appointment letters. And nowhere it is mentioned that this appointment was a stopgap appointment. And what is stopgap and fortuitous appointment? I am referring to some other judgment. This
No,
little bit of doubt there may be created That is clarified in later judgment.
Now, let us assume. Say to the post of PO. The person who became PO earlier than you. Say he is actually junior to you, but he became PO earlier than you because it's by way of option.
Option, yes.
Option doesn't mean that the senior one should get.
Whoever opted, if selected,
So now, if he has the same condition as you, that your promotion would be subject to the seniority assigned to you as SJ, then in that event, what would happen? Because in the post of PO, he'd be senior to you. But in reality, because of that condition, he'd be junior to you still.
no, that contingencies will arise once he is being sent back from the post of protocol officer to his original cadre. When he is sent back, until and unless he's sent back, he's still there, he holds a post substantially. That is a contingency, what your lordship says. That's true.
What?
If he is a PO, because he holds a higher post with higher cadre of higher scale of pay. Suppose Niroj Sharma is a junior man and there are 30 above him. He holds the post of protocol officer. But
No, my question is, supposing prior to Niroj Sharma, someone is a PO,
yes,
is appointed as a PO. But as a SJ, that person was junior to Niroj Sharma. So in that event, because of the rider put in the appointment order, Niroj Sharma will still remain senior to that person in the SJ,
in that cadre, it's
in that
yes,
KJ,
yes.
because of that rider.
Yes, yes.
But in the post of PO, he'd be junior.
He is
How do you reconcile those two
If I may just put
conflicting?
it, Madam, that's true, Madam. When he is in a PO, the other person, junior person will remain senior. But the fact here in our service, Madam, from that post, there is no other post here for promotion. From that post, you don't have an exit. My lord, so that
From which post?
PO. From PO or even APO, the assistant protocol
Why
officer.
not? From PO, you become, you're in the feeder cadre for.
That is
secretary.
different, madam. That is different. That's a picking up thing. There is no selection there. Everybody goes before the Chief Justice and he picks up one. If I may use that word, my lord, he picks up one. There is no selection there, madam. It's the discretion.
There's
of the
no
chief-
rules.
There is no rules. It's the discretion of the Chief Justice for the post of secretary, madam.
Anyway, we'll take it up at lunch.
Then it has purely, it was a stopgap arrangement. If purely the officiating appointment. These are the issues to be looked in. But then, the basic yardstick is the procedure which was followed in filling up. Here lordship will find that the post of protocol officer was filled up by following the process whichever is prevailing in the field now on that. And giving option to everyone,
How do you say that?
because lordship has seen it, my lord, it has been placed on behalf of this honorable court that the procedure prescribed in the committee, by the committee in its resolution. That is the only procedure prevailing.
Let us see the procedure.
That it will be open for calling for options. It will be open for calling for options, and from among them, selection would be made. Ultimately, that was the only procedure which was holding the field at the time. Therefore, this has been placed before your lordship, my lord.
I have given the one file. Compilation of. This one? Two files are there, Milord. One is concerning secretary and another is protocol. No, you have given only one file. Today I have given one file that is with regard to secretary. In earlier occasion, Milord, it came from a raised in the protocol officer file.
Well, this file is with regard to secretary. Top picture.
Down below, Milord.
The appointment of secretary.
Then one of the earlier file was given to the registry court to have it over here. They are both.
In the rules, one of the nothing is specific. Therefore, the resolution which prescribe how to appoint, how to fill up this form. That was taken. as the guideline. That was taken as the guideline and that is the executive instruction. The campaign of the election has got some details also. With regard to protocol officer, records will come, will have a look. First lordship will consider protocol officer. Let us-
Yes,
let us-
so that protocol officer file is required.
Yes, so that our view to that extent is clear.
Correct.
And thereafter, my lord, second stage. That is why when I started my argument on the earlier occasion, I submitted that it clinches the issue if we come to a conclusion that the appointment to the post of PO was substantive in nature, and in that case, the other conditions enumerated in the appointment letter has no bearing at all. No bearing at all. It should not hold us back anymore. Because that eventuality, if arises, then his case to be considered, keeping his seniority in his SJ, that thing is remote. If at all it happens, that is open. But what has troubled the minds, as I can understand your lordship, is that if a person is given a filling, it is not an appointment by promotion, my lord, but nonetheless he goes up to a higher grade from SJ to PO. If he gets the
Now
filling,
this SJ to PO, is there a promotion or what is it?
no, that is, my lord, here, it is direct recruitment. It is appointment in-house. In-house. So the learned Singhal Sahib all the time has considered it as a promotion. No. It's a fundamentally wrong, my lord, in my full submission. It should
No,
not,
but then,
it cannot be
but then,
constituted.
but then. What is, supposing a person is appointed as, that, what is that other post? Judicial assistant, no. What is it?
Senior judicial assistant,
So
then PO,
No, not that, the equivalent to PO, administrative officer.
Yes.
Is that a promotional post?
Yes.
That is a promotional.
Yes.
If that is a promotional post, how can you say that this is not a
because
promotion?
that channel is open for that one.
Is there a, what do you call it, judicial, what do you call it?
Can you page 79 chart?
Huh?
Page 79, the chart is given.
Yes.
No, I don't want the chart. I'm not on the chart.
Rules are there.
I want the rules.
Yeah.
I want the rules.
For a moment, please.
I want the rules, basically. Show me the rules.
So, my lord,
Just a minute.
Yeah.
See, you are, let us be very clear on this point. First of all. Now you see, this administrative officer judicial, you say this is a promotional post of SJ. Now, if it is a promotional post of SJ, please show me where is the, how does the rules provide the procedure for promotion?
promotion, yes. They should.
Page 644.
Just a minute.
Yeah. What you will give us to
Yes, Mr. Parwani.
Page 645.
6:45. 6:45.
645. Yes, 645 from.
Yes.
What status, then promotion.
Yes.
Where? Promotion,
Status and down below status.
Status, then
status, promotion.
promotion. Then come promotion, the caption, promotion,
An employee from the SJ cadre holding the post of postmaster
courtmaster,
will be considered for promotion as administrative officer to
judiciary.
AOG.
As per his
So
rules.
only a court master
No,
can be,
That is the normal line of promotion. Or the post of postmaster. Post of postmaster, extra post. It will be the function of the- Rules are clumsy, my lord, nothing specific is there.
so as per this page 6:45 promotion, only a court master can be promoted. That's what it appears to show.
My friend says that there is one more rule here. This is an employee from the SJ cadre holding the post of courtmaster. He will be in the SJ cadre, but holding the post of courtmaster will be considered for promotion as administrative officer. As merit in the rank of SJ. Lordship may note one thing here in that page, 645. 645 page.
Yes.
Lordship may also kindly take note of reversion. There is a provision, reversion. Prayer for reversion to the original post if made by an employee holding the post of courtmaster may be allowed at the discretion of the authority concerned. So this is also there.
No, but reversion to what post?
It is original post as a, that is what the former rule says.
No, but how can it be? How can it be? There's a contradiction because court master and SJ are in the same cadre. Yes.
Courtmasters are, picked up or they get the option.
They get promoted.
They are not promoted, they give an option and then they are.
They are present.
Courtmaster, same as
Okay.
PO. So it says here, this is what the same thing which is copy pasted for that PO thing, If they want a reversion back, then they will go back to SJ. Otherwise, till they are found fit, they can.
So
continue.
meaning to say what? Meaning to say that their substantive lien will always be in SJ.
My lord can say that, but till the
Then-
time, my lord can say that, but till the time they are a courtmaster.
Now, let me ask you a question.
Lordship.
From court master, can you be promoted?
No.
As per this promotion, you can be.
No, madam. He has to be, his case will not be considered as a courtmaster. His case will be considered as a SJ
No,
for AOG.
but only persons holding the post of court master
My
can be
lord, this is
promoted.
why this has been said is, this rule, if my lord can come to rule 5 at page 644. 644.
Method of procedure.
Procedure recruitment. The post of court master may be filled up by selection. On the basis of merit cum seniority from among the judicial assistant working at the principal seat, having 8 years of experience or both combined. Preference be given to so-and-so having degree in law from any recognized university. Nature of appointment. The appointment to the post of court master.
So
will be
let us be, now let us see.
Lordship, my lord will
Post-
have it.
Post of court master
Lordship,
may be filled up by selection
lordship,
from amongst whom? From
From
SJA and judicial assistant.
lordship.
Now, SJ and judicial assistant means what? Two different posts having different pay scales.
My lord will go further, my lord. Go further. So and so from among so and so working in the so and so, having 8 years of service as SJ or JA or both combined. Preference may be given to so having so and so. Now my lord would come down. Nature of appointment. The appointment to the post of court master will be temporary, subject to review every year. Selection and appointment of an employee will not be treated as his her promotion. My lord has got it. So this is not the promotional channel. This is a
Where are you reading?
nature of appointment.
Yes, appointment to the post will be
So and
temporary.
so with temporary and subject to review every year. Selection and appointment of an employer as court master will not be treated as his her promotion.
Correct. So he remains as SJ.
SJ, but for the time, my lord, he is selected and appointed as a court master.
Sure.
He will be vested with all the powers of court master and he will be in class 2 DD.
Plus two D. Status.
Up.
Gazetted.
He'll be in service of that service. Today, my lord's court master is in class 2 to DD service. If my lord can come back to that,
No, just show me one thing,
lordship,
that other than a court master, a person who is in the SJ
lordship,
can be appointed to the post of AO judicial.
judicial. Because that's the norm, the superintendent, that's the normal. I'll give that rules to my lord. Somewhere, it's somehow missing here, I'll just place that. The normal thing, my lord can take it from me. The normal promotional channel is JA, SJ, superintendent. Superintendent now, administrative officer, judicial. That's the normal promotional channel.
How?
First, judicial assistant. Normal, which is the earlier LDA, my lord. Then senior judicial assistant, UDA, and thereafter, my lord, superintendent earlier, now administrative officer, judicial. That's the normal channel.
But where is the rules provide?
There are, my lord, this one instructions, I'll take that. Give me 5 minutes, I'll take that. But that's my lord can take it from me, that's the way, there will be no dispute on that.
We'll see. You have to
Because
see.
why,
Your submission will have to be backed up by the document.
even in that chart, my friend is referring to, my lord. Page
79.
79,
Notable type.
5 word.
Perhaps at page 645, both this promotion and seniority, the whole thing has to be able to be done. 79, page 645, the entire promotion program and the entire seniority program. Not the-
My lord would see 79, page 79
79 of what?
of that writ appeal number 5, my lord.
Just a minute. $79.
Lordship. Judicial assistant,
Down.
down bottom, well, that's the entry cadre. Promotional avenue, senior judicial assistant, then administrative officer judicial, then assistant register, deputy register, joint register, register. The posts on the right hand side, those are, my lord, direct recruitment posts, not promotional posts. My lord will see court master, then my lord protocol officer, and secretary to the honorable chief justice. That's the,
How can court master be a direct recruitment post?
because my lord, it's in service. It's not a promotion. That's written in the rules. My lord has seen that rules, 645.
It's not a promotional post.
It's not a promotion. It's a, their options are called for, selection is held, and then an appointment is made.
And if they go back, Where do they go back?
They, if they, my lord, in the meantime, they are still in the cadre of SJ, they'll go back to SJ. And in the meantime, if the senior juniors have been promoted as AOJ, they'll have to be accommodated as AOJ. My lord, the question here is not whether it's promotion or something. Once he's made a court master or he's made a protocol officer, then my lord, they are invested, they come to a different service altogether. Because my lord would see the beauty of the rules. Unfortunately, this is how our rules are. made.
Then from secretary to honorable chief justice, where is as per the chart, where can they go?
They'll go to deputy registrar.
Where is that? You have not made it.
That there is
How-
not given.
How can they come back again into the main fold?
No, if it is my lord regularized. If it is regularized as secretary post is regularized, then my lord, he can be considered for promotion as, it will be equivalent to assistant registrar and he can be considered for deputy registrar, which this gentleman was considered, but because of orders of this honorable court, it was not implemented. If my lord can have the rules, my lord,
So a person
got you,
who is a senior judicial assistant,
got you.
he doesn't have to go through this AO judicial assistant registrar line.
Ah.
He can go through the discretionary power channel.
No, not
And
discretionary.
come have a-
no, Not
huh?
discretionary, that's the mistake, Manav, the learned single judgment. Manav, my submission is, that's no discretion there. If he opts for the post of protocol officer, there is a selection. meet. The records are there. There is a selection meet by a committee. Thereafter, he is appointed. He works as protocol officer. During that period, he works as protocol officer. He would be, my lord, if lordship can just have paid 638.
No, wait, let us go back again. Let us,
My lord,
we're
may I do
jumping
one
the
thing?
gun again.
I have been only, my lord, trying to fill in the blanks. Can I just take my lord through the whole thing once, my lord, so that I can just place it? Because I've been only filling in the blanks. one. Maybe I'll try to clarify that issue with the rules. Sir, review. My lord would come to the rules. Page 638.
Now, prior to that, I just want one thing. Out here in this appointment to the post of PO.
PO.
Where is the two resolutions passed by the,
Lordship, it is. You, it is. My lord would come to page 54C. That means, my lord, in that, no, not in the note sheet. The down below, in that bunch, 54C, page 54C. Well, my friend will take it out for me. It's a slightly,
there is 54, there is no 54.
there is. He'll just write that. If my lord can have the notes that my friend had given my lord now. The second page that. Conveyance compilation for records of protocol officer.
There's so many papers. Yes,
My lord would have the date 25/7/2014.
yes.
Lordship. Regarding minutes of the meeting of the committee.
Just a minute. I want that resolution of 4th June 2014. 4th June.
June. My lord had taken it from.
No, because this, I think, this,
Well, it should be 8th June 2000, it should be 10.
is there a 4th June? Or
4th
is,
June, Manoj,
is there a 4th June or is there a,
It should be 8th June 2011. when, my lord, the post was encadred with retrospective effect from 25 to 99.
No, on this 25/7/2014, I think they have mentioned 4th June.
My lord, 25/7 of 4th June 2008. 25/7 of 4th June 2008. 7/2014. নাই তাকে বলেছেন তাকে 4th June কি বার reference
In the agenda for 25/7/14, have they mentioned 4th June?
Final one is, my lord, 9. Can. What should I do? I'm sorry, madam, this file was given last week itself to be handed over. Unfortunately, it was not. 28th.
You see, unless, because, like, Mr. Mahanta had said, unless we go first into this PO issue,
Other part will take care of it.
PO issue, then we can go to the next
My
one.
lord, one thing, my lord, if I may just point out what is happening. There was a move how to do it. Then, my lord, it was decided that it will be options. Taking options from the chance and SJs. Thereafter, there will be a selection and thereafter there will be a appointment. This was, my lord, further confirmed on 9/3/2015 minutes, wherein it said that 25/7/2014, this option thing was finalized. That was continued, directed to be continued with, and my lord, it was said that they will maintain their seniority in their respective seniority in the original cadres, and their further promotion will be considered on that basis. If my lord can have it. 25/7/2014, my lord.
No, they are not. This is for 25/7.
25/7.
25. Now you see, 25/7
Lordship.
agenda, the first line you read.
Hmm.
Consideration of this registry is not dated 4th June 2014. Where is this 4th June?
2014.
Yes, I will mark it here.
Oh, Lordship.
I will mark it this.
Lordship. 14.
Ah,
Okay, so my lord wants that notification. It's 24th June. No, 4th June. That's it. If I might just take my lord, he's finding it. First, there was that options would be called for. Then in 9/3/2015, it was said that the seniority would be fixed in this manner. And thereafter, my lord, there is no decision on this aspect.
in which resolution?
9/3/2015.
Okay.
After that, there is nothing, madam. That was the method and methodology prescribed for promotion to, for appointment to this post. Now, how this appointment is made, options are called for. That, my lord, would find in the note also. I've given the examples. Options were called for. And thereafter, there was a selection. And that selection finally was approved. And thereafter, the person was appointed temporarily. He was, my lord, given the higher scale of pay. He was vested with gazetted status. And for the period he is there, my lord, he would be in 2C. Service 2C, whereas he originally is in 3A. So for that time being, whenever he is there, because this is open-ended, my lord. It's not that it will be
So, so SJ is 3A.
3A.
Hmm.
And he comes to 2C.
Hmm.
Now what had happened? There is an interesting factor here. This gentleman, Niraj Chauhan, who was working as a protocol officer, was selected by the Chief Justice to be his secretary. But that appointment was made on officiating basis. So naturally, the protocol officer post cannot be kept vacant. It was advertised. Selection was advertised. But the person who was appointed on officiating basis. Why? Because he was there on officiating. So that shows, my lord, that this post, this appointment as protocol officer is a substantive appointment for all intent and purpose until he is continuing there. Now what happens, my lord? This is not under challenge. This protocol officer thing is not under challenge.
Maybe.
I'm not even saying my lord, that should be the clinching factor. It's not under challenge. So that appointment as protocol officer stands. Now
Appointment as temporary, whatever.
Whatever it is.
The nomenclature used.
use whatever the nomenclature be. He stands and he works as a protocol officer. Now the question of selection of chief secretary, chief justice's secretary comes. Now the honorable single judge has said that there was no discernible procedure. Right from, my lord, the time this has begun, there was no procedure. What the registry does is, it collects the information of all the persons who are to be included in 373A. 73A who have to be included. These particulars with a note are placed before the Chief Justice. And it's the Chief Justice who has the prerogative and discretion to pick up one person. And he accordingly, of the persons working in these services, it is, my lord, 2AA, 2B and 2C. If my lord can have that rules for a second, my lord. 638. 46. That note is here. Now, sir, now my lord would have 638 for us. That's the note. 464. The whole file, my lord, that's why the numberings are all in a jumbled up shape. And my lord would also have the previous notes, in the previous pages. He should have. The green pages.
Just a minute.
Even to.
What about this notification, this resolution of 25/4/14? Have you made a mention of it here? 25/4/14? No.
No, madam. I have mentioned 25/7/14.
You see,
It may
25
not be a resolution, but maybe also.
may not, no,
It's a agenda. It's a putting up thing.
yes,
My lord will have to then, my lord, go 25/7/2000. 28N.
out here it says something to the effect that as such, the post of assistant protocol officer is a promotional post from cadre of judicial assistant, whereas the post of protocol officer is the promotional post.
Post. That was the system, my lord, that was then not considered 25/7/2014.
25/7.
28N, madam. 25/7/2014. Flag mark, madam.
Pink flag.
Pink flag. It will be
pink, no,
the long ones. 25. My lord will have that. 25/7/2014.
That pink flag, my lord.
This one,
Yes.
25/7.
25/7, yes.
My lord would have that. Therein, my lord would find. So this was the methodology applied. Then my lord will have to go to
Just a minute.
lodge. My lord has got that 9-3 also, 9-3-15. My lord can have that 9-3-15 Xerox also. Hey, Rakesh. Hey, 54C, that's it, 54C. 54C complete. Green flag. No, my lord will not, only these two will be. The 54C. My lord has that. The third copy. So my lord has seen that how the post is to, because in the rules there is no prescription. This was the prescription date. And my lord would mind it's an appointment. Rules, the resolution also said. Lordship. PO. Appoint. He will not, man, until and unless he is not selected. Not a promotional post. The direct recruitment post. if he is regularized there, then my lord, because my lord would consider one thing. These posts have been kept in this manner because these are orderless jobs. Protocol officer, it's a 24/7 job. And but the rules have been framed in that manner, my lord. We can't go beyond that. We can't go beyond that. So if a person is, my submission before my lord is limited. And I submitted this before the Honorable Single Judge also. I'll show my lord how it was there. That the time he is appointed as a PO, he is in class 2C service for all intent and purpose. Because my lord would see the difference now that is being created. 3A, he's not a gazetted officer. He's getting a lower pay. Moment he becomes a protocol officer, he gets gazetted status. Plus higher pay. And a difference in service. Because if that is not conferred on him, that works may suffer. And this is not limited by time. That Baleshwar Das's judgment, that paragraph, if now my lord reads to that extent, then my submission, my lord, I would be better, I can be more clear with it. So it's not limited by time. He stays there. In that view, there may be many protocol officers who may not have had this opportunity. Because that point of time, a Chief Justice came, a secretary was required, because the earlier one became a, my lord, promote. My lord, that one, my lord. What about, yes, my lord, correct. That is why, my lord, initially it was made on officiating basis. It was seen. And thereafter, my lord, it was said that, okay, fine. The reasons given, there is a separate sheet of the Honorable Chief Justice, then Chief Justice, emanating the reasons why he wanted to condone the law qualification. And he made him a regular. Now, my lord, say a person is not regular there. As secretary. And a new Chief Justice comes. Well, that situation cannot be just brushed under the carpet. It has to be dealt with. He, my lord, does not want him. He wants this exercise to be done afresh. Then that man will go back to the service from which he came. That means he will go back, in this case, as a protocol officer, if not regularized. If regularized, then, my lord, he will have to be accommodated in the equivalent post, that is assistant raised. If not, he'll go back. Otherwise, there can be no second, my lord, option. Now, my lord would have an interesting factor here, my lord. If my lord can have writ appeal 5, the judgment. No. No. My lord, it's not that he will become a secretary. If lordship can have the schedule, my lord, 1 second. If my lord can have the schedule, 1 second. If my lord can have this schedule, I think, my lord, this will clear the issue. 664, my lord. My lord would see the pool for the secretary post is 665 down, class 2C. My lord has got it. AOJ, stamp reporter, court officer, protocol officer, assistant librarian, senior system officer. So these are the incumbents in class 2C. Above that, class 2B. This is the stenographer's grader. Then, my lord, comes class 2AA. Librarian, comes senior research officer and senior private secretary. Stenographer again. Then comes class 2A. From class 2C, my lord, but for the post of administrative officer, judicial, stamp reporter, court officer, then, my lord, these 3 posts, their promotional avenue is assistant registrar in class 2A. It's there in the procedure, madam. They get it, madam. AOJ, that I'm getting from the registry. I'm placing it before your lordship. My lord, that's the my lord will this. There is nobody can dispute this position. I'll place that for your lordship. Today itself I'm placing it. Oh, my lord wants the SN register one. My lord, SN register one is at 640, my lord. Serial number 3. My lord would have, sorry, my lord, I was under that JA and AOJ thing, my lord. Here this is provided for, SN register. The SN register shall be appointed from amongst the state judicial service grade 3 or by promotion from amongst gazetted officers of the High Court service belonging to 2B, 2C and 2D, or from among advocates of not less than 5 years continuous practice at the bar. But as a matter of course, when my lord is seeing the pool of a feeder cadre of my lord SN register, they come in, my lord. Now, because of that tagline, my lord, that if I may use that word, my lord, that your seniority would be fixed in that SJ cadre, normally protocol officers are not considered under 3, normally. But for all intent and purpose, they are there. Now, if they are there, and my lord, the exercise of Chief Justice is being considered, then his name is also sent. And it's thereafter the Chief Justice's discretion. There is no procedure prescribed. No, I'm talking about 3A, my lord. Secretary, page 640. Secretary to the Honorable Chief Justice, 7-3A. And my lord would have its gazetted officers. The Secretary to the Honorable Chief Justice shall be appointed from among the gazetted officers of High Court service belonging to class 2A, 2B or 2C having a degree in law considered suitable by the Chief Justice. Now here, because at the time when these rules were contemplated, my lord, these posts of protocol officer were ex-cadre posts. That was created thereafter. It was encadred, but the procedure was not prescribed here. That is why my lord requires that those 2 resolutions of the, my lord. If I can have my lord's attention just for a moment, my lord, at 106 of this writ petition.
No, this is the 2nd June, right? The 4th.
My lord will just give it. My friend will find it out for you. Office no. It will be in the last end of the. If my lord can come to 106, my lord, of the writ petition 5. If it is promotion, what would be the, my lord, criteria? This is the formulation now. How the merit with regard to seniority, what would be the zone? This is the issue. But my lord will not find this applied for the post of court master or for protocol officer. Forget, my lord, the Chief Justice, Secretary. This is for the normal promotion channels. Now, what is happening here, what the Honorable Single Judge has said, my lord. If my lord can come to page 171. Okay, good. 171, my lord, would have para 30. Analysis of the rule makes it, this is 73A, my lord. Apparent that the appointment to the post of secretary or to the SJ can be made on fulfillment of the following ingredient from gazetted officers of the High Court Service. Such gazetted officers should belong to 2AA, 2B, or 2C. Said officer should have a degree in law. This is, my lord, where the condonation comes in. The officer should be considered suitable by the SGA. The first three ingredients are objective in nature, and only the fourth one ingredient, namely suitability, the subject element of subjective satisfaction, would come in. There is also no dispute that the post of protocol officer belongs to class 2C. The aforesaid rules are also to be read with Rule 63A, which gives discretion to the HA to relax the qualification for appointment. It's quoted here. Now, my lord would come to the next page. 32, my lord. 63A. The Chief Justice shall have power to relax age or qualifications for appointment to the service of the High Court in appropriate case according to his discretion. Service. It would mean all, men. It would mean all because this is an appointment now again to a different service. It is, my lord, to class 2A from class 2C. It's a different service altogether because we have delineated the various posts into services of the High Court. That is rule, if my lord can have that rule, 3, if my lord can have that rule, 3, 638. Classification. The services of the High Court shall consist of both the gazetted and non-gazetted posts shall be classified as follows. High Court Service, class 1. High Court Service 2A, 2 and 2A. High Court Service of Private Secretaries, now 4. High Court Ministerial Service, class 2C. Wherein, my lord, AOJ, Protocol Officer, all 4. Now, my lord, if I may just take my lord further. This, my lord, he discusses that the 32, my lord. With the aforesaid backdrop, the concerned interpretation thereof by various judicial pronouncements, the records of a case has been placed in original required to be. The Honorable Chief Justice White endorsement dated 4/9/2018 had recommended the name of the respondent number 5, who was protocol officer in class 2C. My lord would see the judge, he is also accepting that fact. For appointment as secretary so-and-so on officiating basis by endorsing the condition in the note that he will maintain seniority in the original cadre of so-and-so. Consequently, the notification dated so-and-so was issued. The file further reveals that a subsequent exercise was done, which was proposed by a note dated 3/7/2020 on the issue of regularization of the post of so-and-so. The note also contains an observation that on earlier occasion, an incumbent was posted to the aforesaid post who did not have degree in law, and also that absolute discretion may be given to the Chief Justice to appoint any suitable person to hold the post. The said note was approved by the Honorable Chief Justice on so-and-so. The approval was on the following considerations which are required to be put on records. My lord, actually what had happened here was, on the records it will be clear. The registrar's note was approved. He gave an additional note. This is the additional note. Considering the consistently good work done by so-and-so while attached to various Chief Justice as depicted in his ACS, the efficiency, integrity, punctuality, dedication towards duties without taking break, knowledge of computer application, thoroughness in performance of all tasks, searching judgments, preparing templates of judgment, quality of interaction with officers, officials. That note, my lord, would find. Endorsement dated so-and-so, 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 by 3/7/2020. 3/7/2020. It's there in that secretary file. My friend is finding it. Secretary file. It would be an item. My lord, it's page
126 M.
2020. No, registry note book. 4/7/2020, full Chief Justice. Everything on page 4/7/2020. What is it? My lord would find it at 3/7/2020 at page 126N. And the note of the Honorable Chief Justice 4/7/2020 at 132N. Note sheets, ma'am. Give me the note sheets.
But you will find some pages to be given N.
Would be written as N, ma'am.
After the numerical, there will small N will be written. Well, I'll just find it out.
Written. One 26N, 132. एक मिनट. Let's see. 152. 132. 152. 152. 156. Get a one. One 32. It's marked. In the note. My lord would have the note dated 3/7/2020. 126N. It will go till 132. My lord will have 131. My lord, during the endorsement of the Honorable Chief Justice is there. Mm. 132, 126 onwards. 32. He's not, my lord. Judgment. That endorsement, my lord, would find there. There is an endorsement, I think, on page 130. (126N to 130). Now, my lord, this is the notes given. Now, my lord would see how the Honorable Single Judge has there. 173, para 33. One line.
Yes.
The aforesaid consideration in the opinion of this court, while exercising powers under so and so, cannot be termed to be adequate. My lord, how can an adequacy be gone into in this proceeding? If it was perverse, it would have been a different thing altogether. But adequacy could not have been gone in. And that created the whole problem. The negation of this note on the ground of adequacy, my lord, resulted in the conclusion that was finally arrived at. If the Honorable Single Judge could have from record said that, no, these conclusions that have been raised are perverse, we will not go into it. Then, my lord, it would have been a different question under judicial review with regard to material. But under judicial review, when my lord is reviewing an order, adequacy of reasons cannot be a problem. And my lord would find subsequently that this prevailed and led to the final conclusion that this appointment is bad. In my humble submission, my lord. And my lord would also have para 34 at page 174. This court is also of the opinion that power vested in Rule 63A, which is discretionary in nature, has to be exercised in reasonable manner and for a situation of necessity. There is no dearth of eligible candidates in the feeder post having requisite mandatory qualification to be considered for the post of secretary to HCJ. When there are a number of eligible candidates, there was no occasion to at all to take recourse to the relaxation powers under so and so to give a benefit to the respondent number 5, who is otherwise not qualified to be appointed as secretary to the HCJ. My lord, this is my humble submission beyond what could have been gone in a judicial review. Subject to what my lord would say finally. Why I say so, my lord? This post of secretary is not to be filled up in the normal parlance of promotion or direct recruitment, selection, merit list, waiting list, all those things. It's totally absent here. The only thing here is the names of all in those 3 categories will be placed and he will make a choice. How he makes a choice? It is his thing. He makes a choice and he appoints. That post is a permanent post. And he desires to have that man regularized after having watched for around, my lord, 2-3 years. He has watched him. Other chief justices have given very favorable notes. So he comes to the conclusion that, see, because of this lacking in his qualification.
Can there be such an untrammeled power?
My lord, when it's power of the chief justice to appoint his secretary under the rules, that power, that benefit, that space has to be given to the chief justice.
Shouldn't there be some kind of?
That's, my lord, that if that is to be laid down, that has to be laid down. That can be laid down, but that will be a prospective action. As on date, my lord, there is no such thing. And what we have, we'll have to follow that. I have told my lord that we have many lacunas here in the rules.
What about when you invoke the relaxation provision or the discretion provision? Shouldn't it have some restraint, or you can do it as you like?
My lord would have, my lord, that power which is being given to the Honorable Chief Justice under 63 is all pervasive, but subject to the proviso. The proviso says if it is relating to salaries, allowance, so and so, then the approval of the government is. Otherwise, this is totally, my lord, he has the total discretion. Now, my lord examines those reasons and finds that those reasons are not germane. I'm using the word germane or perverse. Then my lord will interfere. Because any administrative action of the Chief Justice is subject to, my lord, judicial review. But my lord will not interfere with those on the ground of adequacy. The merit of the decision has to be seen, not the adequacy of the reasons. And nothing in this rule shall be deemed to affect the power of the Chief Justice to make such orders from time to time as he may deem fit in regard to all matters. No matter. The Chief Justice shall have the powers to relax age, and it also says qualifications for appointment to the service of the High Court in appropriate cases according to his discretion. Now, if that discretion has been exercised on some, my lord, grounds which are germane to the issue, then, my lord, on the ground of adequacy, my prayer would be, your lordship will not interfere. Because there is nothing shown that these were perverse, that these grounds are non-existent. Nothing has been shown. So the grounds are germane to the issue, having a nexus to what is sought to be achieved. It's the service rendered by that man. Then the adequacy thing will not happen. This is my humble submission.
What about now regarding the appointment as a PO?
Lordship.
The use of the word temporary.
My lord, these are misnomers. Temporary. My lord will take it that it's temporary. But my lord, it's without time. It's not for a year. a month, a day. It's without time. He can continue.
But there's a stipulation.
I'm coming to that. My lord will continue him, say for a day, finds it bad, send him back. But for the time, my submission, my lord, I could not get it across before the honorable single judge. I'm trying to get it across to your lordship. My submission is, my lord, very limited. That during the period he is in class 2C, he will be a member, a protocol officer in the post of protocol officer. He will be a member of 2C, my lord. Then whatever exercise, only exercise that can take place is secretary. Others will not come in, my lord. Secretary. If he is also placed, there is no illegality. There is no illegality.
What was the reason for putting that stipulation? Then why couldn't he have his seniority?
That's because, my lord, I told my lord last year or last time also I submitted before my lord. We proceed on what they call it, my lord, stop and start method. What I find from the files file. There may have been a contemplation that we will look into it subsequently. That looking in never happened. And this is not the only instance in the High Court service, my lord. There are many such posts, my lord, where a detailed looking in is required. This formula that has been adopted was at that point of time, something happened, my lord, this was brought into operation. But thereafter, my lord, that was never considered subsequently, unfortunately. Maybe it was not placed, maybe before the committee. But all selections, my lord, will see from the records, all selections approved by the committee, by the administrative committee, appointments committee, and thereafter interviews were held, and thereafter appointments were issued. And my lord, when Niroj Sharma was appointed on officiating basis as secretary to the Honorable Chief Justice, this protocol, Vidyut Vikas, no? One Vidyut Vikas Goswami was appointed, but he was appointed as on officiating basis. Why? Because he is sitting. What does that infer, my lord? That infers that this man had some hold here, that post. It was not just I will not use the word lien, my lord. It was not just a out of ad hoc sort of an appointment. It's a regular appointment. But for a time which is unspecified, if I may put it that way. And there is another reason. He becomes a protocol officer. They say, just like court masters, they say that your seniority will be maintained there so that you can come up. Once you become AOJ, then it will be only an adjustment. Same service, it will only be an adjustment. Maybe that was the concept, because that's not very much reflected in the minutes of the judges committee. They took a decision. This is the one, and I find, my lord, that maybe there was a hope that we will look into it in future. There was never a dispute, so there was no occasion of looking into it. And I implore upon your lordship that in the administrative side, these are the things, barring all these cases, my lord, these are the things which have to be streamlined. Not only for this post, there are many posts like this, which requires a streamlining. And over 1967, my lord, we are now working in patches. We are putting patches there whenever a situation arises. But we have not overhauled the thing. It has to be overhauled. But till that overhauling prospectively happens, my lord, this is the Bible we have, and we'll have to follow that. Because in absence of a procedure, it is the judges committee reports that will hold the field, the method of selection and promotion. It's not promotion, method of selection, appointment. Now, humble submission, my lord, that there was no irregularity in the
Show me in the rules,
lordship.
is there any, what is the procedure to be followed for promotion as AOJ?
AOJ, my lord, I'll have to get that. It's not there in the rules, but normally it's from this SJA, my
No, that is all right.
lordship. It's not there in the rules.
If it's not there in the rule,
They, my lord, again, as judges committee has said,
then the protocol officers post also is not there in the rule.
no.
Now, how do you say that appointment to the post of AOJ is by promotion, but not to protocol officer?
Because that is what was laid down by the committee, my lord.
But where does it say that AOJ will not be?
Because it's not promotion, because they are calling for options. If it is calling for options, then it cannot be promotion. It has to be my lord, because if it is promotion, then my lord, 1:4. One post, only the first 4 can be considered as per our rules, my lord. As per the formula we have.
Why can't it be promotions only for those persons who exercise their option?
But because my lord,
Because some persons might not want to get promoted.
my lord, that's why the options are given.
So-
My lord, there is a concept in service law wherein, my lord, you can have in-house direct recruitments. It's not foreign to the,
Maybe. I'm
it's
not
not
saying,
foreign.
I'm not supposing,
My lord,
assuming there is,
there is.
but where does it say here? That the appointment to the post of protocol officer,
My lord,
We-
when
we-
my lord will make it promotional,
Huh.
then this option thing will not work, my lord.
I
This
don't-
option, yes, my lord. Because this option thing will not work because the first 4 persons will have to be given the first option.
okay, show me the resolutions with regard to how the post of AOJ is being filled up from AJ.
Within, before my lord revises, it will be in your, my lord's. I'll ensure that. I'll have it. before.
No, no, you have to show me. I have to see.
I'll place it before your lordship. I think. Today itself, my friend will have it before my lordship. Ah. So, my lord, in this view of the matter, the rules as it stands today may be bad, may be wanting, may be lacking in many respects. But that's the formula, procedure we follow, and we have been following. That's how we have, my lord, resolved to lead us forward. Tomorrow, if there is a change, that will be prospective. Till today, this is to be followed. And I again reiterate that the person, my lord, will not see whether his seniority is there, here, where, but he is in a substantive capacity unlimited by time in class 2C. Till he is a protocol officer. My lord removes him, finished, he becomes 3A. But till he is there, he is a member not of 3A. It does not say, my lord, he'll be member of 3A. And my lord, it's not a post wherein he is holding it on charge basis. It's a full-fledged appointment with the scale pay attached to that, and in addition to the gazetted status conferred. Same as court masters. And court masters, there is a requirement in the rule that 1 year review. For protocol officer, that is also not there. So, my lord, my humble submission is that he is a member of 2C. Then how he gets selected or not selected for Chief Justice Secretary, it's a discretion of the Chief Secretary. Because there is no norm. It says that there was no semblance of an. There is no norm, my lord. It's his discretion. Tomorrow, my lord says that there should be a particular norm, that will be prospective. In my humble submission, my lord, the honorable single judge's decision, the reason is one requires to be interpreted. This is my humble submission. And this the 2 things, my lord, I'll have it for you. My lord, I'll have it. I'm sorry, my lord, I did not contemplate that before, my lord. I'll have it for you.
If you were supposed to give me all these files.
No, my lord, we gave it to
On
the.
Friday.
No, I gave it, my lord.
Yes.
We gave it, but
It
the
is
there's a note also there. But I don't know why, my lord, they did not place it before your lordship. Note was in it. Because then he told me that they'll put up notes, and then I said, no, you give this file directly. The second file was given directly, my lord.
Anyway. Because suddenly bringing this, scaring you, trying to turn the pages won't work.
My lord, only 2 pages in protocol officers. That is, my lord, if then for my lord's satisfaction, my lord can look into the selection methods. But otherwise, these are the 2 resolutions, which 9/3/2015 and the July 2014. Otherwise, there is nothing, and the Chief Justice's notes in that, and the registry's note for regularization.
No, because you see, in 2C, there are many other posts besides the post of protocol officer. Now, those persons, how are they appointed to those other posts? Who are in 2C?
My lord, 2C, the posts are, I'm placing it.
5 of them, 5 posts.
5 posts. administrative officer, stamp reporter, court officer, and assistant librarian. They are, my lord, covered by, my lord, Rule 7(3). at 6:40, my lord. The assistant registrar shall be appointed from amongst the state judicial service grade 3 or by promotion from amongst, here the word is specific, my lord, promotion. From amongst gazetted officers of High Court service belonging to class 2B, 2C,
No, this is assistant registrar.
Rossip.
I am not an assistant registrar.
My lord wants how they come in.
No, you see. My question was with regard to stamp reporter,
Stamp reporter,
Court
my lord, is
officer,
again SJ.
assistant librarian.
Assistant librarian, my lord, is
Senior
it's
systems
there.
officer.
Assistant librarian is provided for. Assistant librarian is provided for. 6:33, 44, my lord.
6:43 down below.
43, my lord, 2(1)(a). Down below, my lord. 2(1)(a). Assistant librarian shall be filled up by promotion from the post of library assistant having 4 years service in the post of library assistant with degree in law,
And
so and so,
Court officer.
Court officer, my lord, would find, and it's there, my lord. Court officer just after that.
Anyway, there's
Court
no
officer.
time now, there's no time.
Court officer, my lord, is at page 646.
Mr. Nair, I think there's
Lordship.
no time.
My lord has
For the reference.
My lord can have it tomorrow so that, my lord, we can finish it up second. I'll have those things also before you.
2 o'clock.
Whenever it's convenient, my lord will, if the list is over, my lord, we can. After the list, my lord. If possible.
Tomorrow, I've got, we've got a lot of work.
Then Thursday, my lord. No, they are not.
Huh?
Thursday will. Vacations.
I know. And
Tomorrow, my lord, only that thing has to be handed over, my lord.
no, we have to hear, I've got to, I've got no questions, I've got to go through the, you see, I need some answers.
Lordship, we are here, my lord. We are here, my lord.
Once I go through this,
My lord will have
questions
that
will start
question.
coming.
Lordship,
I need
understand.
answers.
Understand, my lord.
I cannot,
No, my lord will have,
Yeah.
my lord will have to go into it, my lord.
and it's not, you are making it tough for me to decide at one go. I've got to go and make it, and in all probability, it'll go up. It will go up. That's, I think 120% guarantee.
That, my lord, is. My lord, I
have
know,
to
my
be
lord
careful.
doesn't care for that.
I've got to be careful that at least my decision seems
Will
to be
happen.
quite plausible.
Lordship.
Or, that it doesn't look me,
No,
doesn't make me
It should
look
not.
like a fool.
no, it should not be, my lord.
Both of us, in fact.
It should not be, my lord. That, my
No,
lord,
we
we
have got
never,
to-
we
No,
never
It's
would.
not that, it's not that. I'm not questioning your competence.
No, my lord, I got
It's
what
us.
my lord is.
We have got to be careful.
Lordship, that's the minimum required, my lord.
Anyway, so, tomorrow, okay, we can try if we have got, I don't think we've got time. We've got too many cases. In DB also we have full, the list.
Let it be, my lord, if possible.
If possible,
If possible, at 2, my lord.
Truth or no chance? No chance. With single bench I've got,
Oh, my lord has a single bench.
yeah, they've given me, I've been told just now, 15 matters. I think because too many motion matters.
Motion matter, maybe.
Motion. Because of that.
Just before vacation.
So everyone is,
Let it be fixed, tomorrow, but that anytime if provided time permits.
if time permit. Huh? Okay, supplement your list tomorrow. If time permit. If it doesn't, then it's all right. Get time for it. List the matter tomorrow.
My lord has a single bench early or?
No, I've got DB, then I've got single.
Then again coming back, maybe.
Again,
But my lord, we'll just have a try in the.
we'll try, get time.
Much obliged. All right.
Oh.